10.
9. Yes, week 10 rather, week 10.
Yep.
Change that. All right, we live. Wait till it's next thing, then we'll get started. Cool. Perfect. Hello and welcome to the Lost Confederacy channel. This is week 10 of the 13-week fiscal program of recovery for American prisoners of war. Today you have myself, Chief Biko, as well as Chief Alligator. Chief Quietwater will be joining us a little bit later within the program. And as always, we focus more so on that first letter in the acronym APOW, which is American. As always, before we get started into our readings, definitely just want to get a quick summary of what we've been discussing pretty much over the past, I would say, month and a half, which is that 1968 Civil Rights Act. And as always, we want to continue to repeat or continue to hear and see what was being said at the time by the President of the United States, which was Lyndon B. Johnson, in regards to this act. And again, just continue to pick apart what he is saying and make it come to life in regards to the document that we're reading. So without further action or without further ado, I'll go ahead and share my screen and we'll jump into it.
President Johnson talked to Chief Klaus about America's responsibility in a time of crisis and challenge. Word came from Capitol Hill that Congress had passed and sent to the White House the Civil Rights Act of 1968.
It's not loud enough, Chief Biko. You need to turn it up.
Which, when fully effective, would forbid discrimination in
The volume's low. Let me see.
Offered for rent or for sale.
He said it's not loud.
Right, the volume's low.
Sure why it does it. Maybe because my headphones are in. Yeah, plug these real.
Chancellor Klaus about America's responsibility in a time of crisis and challenge. Word came from Capitol Hill that Congress had passed and sent to the White House the Civil Rights Act of 1968. Included in the measure was a landmark open housing bill, which, when fully effective, would forbid discrimination in approximately 80% of all housing offered for rent or for sale in the United States.
I do not exaggerate when I say that the proudest moments of my presidency have been times such as this, when I have signed into law the promises of a century. I shall never forget that it is more than 100 years ago when Abraham Lincoln issued the Emancipation Proclamation. But it was a proclamation. It was not a fact. And in the Civil Rights Act of 1964, we affirmed through law that men equal under God are also equal when they seek a job, when they go to get a meal in a restaurant, or when they seek lodging for the night in any state in the Union. And now the Negro families no longer suffer the humiliation of being turned away because of their race. In the Civil Rights Act of 1965, we affirmed through law for every citizen in this land the most basic right of democracy, the right of a citizen to vote in an election in his country. In the 5 states where the act had its greater impact, Negro voter registration has already more than doubled. Now with this bill, the voice of justice speaks again. It proclaims that fair housing for all human beings who live in this country is now a part of the American way of life. We all know that the roots of injustice run deep. But violence cannot redress a solitary wrong or remedy a single unfairness. And we just must put our shoulders together and put a stop to both. The time is here. Action must be now.
Chief Biko, can you go to the beginning, right when he starts speaking? Right when Lyndon Baines Johnson starts speaking on that video?
You said go to it?
Yeah, right when he starts speaking. And hit play again one more time and stop it once he says we have signed into law, and then hit pause.
Gotcha.
I do not exaggerate when I say that the proudest moments of my presidency have been times such as this, when I have signed into law.
Stop right there. That's what we're saying to our people. It really came out on Sinetta's TV. We talked about it yesterday. What we're showing our people is Negro, Black, colored, or Afro-American has never went through the government procedure and then got signed into law by a president. I'm of the mindset that it starts there. It's been over 245 years since the government has never defined us in law for over 245 years. Common sense and adulthood tells me they're not going to do it, but you at least make that the initiative for the next voting cycle. And when they can't do it, then what other reason do you have to keep supporting this shit? That's all I want to say on that.
Definitely completely agree with that. That is the starting point. Again, until they define us within law, and as you stated on Friday when we did our Juneteenth build, not a definition that they give us, but how we define ourselves and put that into law. Until they can define us, which basically means until they recognize our group, until they're willing to do that, nothing else should be talked about, should be on the table, should be on the agenda. Because if they're unwilling to actually recognize us as a group of people, what is there to talk about? Nothing. So no, I'm definitely in alignment with what you're talking about there, Chief.
Chief Quietwater, where you at with that? That if the government—
I agree as well. I think that as this information gets out, that we just all need to be on one accord, like this whole voting stuff and, you know, trying to find the best candidate that's going to represent us. There's no representation. So I feel that, like both of you said, like first we have to start at being recognized, because everything else is basically a moot point from that point forward. So I agree with you guys as well.
Absolutely. Absolutely. Like I said, instead of trying to vote for somebody to represent us, can't represent something that's never been recognized by this government in the first place. So yeah, I think we're all on the same page as far as, you know, that being the foundation and the starting point. If that can't happen, no point of even giving your time, your energy, your money, your resources into this government. Let me go here. And just to bring it all together before we jump into the readings, I'm going to always continue to bring back this Title II of what we're currently reading, which is the 1968 Civil Rights Act, also known as the Indian Rights Act, until we can see something, what I'm about to share on my screen. Then, as Chief Quietwater stated, everything else is a moot point. So when we say actually define who we are, this is what we're talking about. Again, you know, repetition is key to learning. So again, this may become, you know, boring to some, or, you know, rudimentary, you know, as far as just saying the same thing, but we have to really enter and understand what we're saying in regards to that point we just made. Until we're able to see Black, Negro, colored, African-American means and then the definition of what we state it means, then all of this is for naught. So until we can actually see, or till Congress actually defines what, again, Black, colored, Negro, African American actually means within law, then what's the point of supporting a government that does not recognize you and just uses your energy freely without giving you any type of resources, let alone a definition to what or who you actually are?
I'm gonna go one step further with that. Once we are defined, we need to be defined. Okay, we are the Indian. We understand that on this channel. Historically and through law, we are the Indian. We also understand there was a second Reconstruction in 1968. 1 week after they killed Martin Luther King, they slid this in the back door. Now, we're not going to throw our people under the bus, but there has to be a line drawn in the sand. It's been over 50 years since this document was written. This is not a part of any school curriculum. I personally have never heard any historical scholar cite to this act and cite to this definition of Indian. So moving forward, y'all can't jump back in front of us because you've had 50 years to educate the group on this and wake us up to this. But instead, what people chose to do, and again, not throwing you under the bus, but I'll be damned if insanity is doing the same thing over and over, expecting a different result. We get it. Some people got deals up under the table. Those that were aware of this definition in 1968, some of y'all slid in and got your Indian rights. We get it. But what y'all can't do is try to jump back up 50 years later and think that y'all are going to get in front of this real movement that's moving forward. That's in-house, and that's something we're going to have to clean up in-house. We can't let these same brokers, because that's all it was. They played broker. They were the middleman in the deal. They took a small percentage and they were able to register as Cherokee, Choctaw, Chickasaw, Seminole, or have their own independent nation. And the rest of us just got thrown to the wayside. Now the rest of us are waking up and realizing what happened. You're not going to jump in front of us and try to spearhead any kind of momentum because we have to learn from what happened. But in addition to being defined, we need our own government. And the United States government needs to assist us, just like it did Israel, in having our own government, our own court system. And we take our people out of your system and you give our people back to us. If we're not thinking that big, nothing else is going to work. We had our own. This is the new world. This was the new world when they came over here. Towns with running cars and railway systems were giving you the people who invented all of this. It's our stuff. You're going to front us a government, and we're going to clean up the language that y'all did to the fake Indians in the 1968 Civil Rights Act. You're not going to be parent company over us. We will be independent. Anything less than that, people, we wasting our time. That's the whole point of showing this information. It's time to stand up. And we've caught them in lie after lie after lie in writing. I'm gonna stop right there and let y'all build on what y'all think about not only being defined, but the same thing when you traded places with us in 68 and you gave the rights of Indians, the power of self-government, the power of an Indian court, and you define what an Indian is and you define what a tribe is, you got to do the same. You're going to do the same thing for us. It's not a begging situation. It's we caught you in your lies. Come on, come clean with it. Chief Wide, what y'all got on that?
And my thing is too, in regards to us just waking up, I think that it's definitely a slap in the face to see all these immigrants that are coming here for refuge and, for protection. And again, like we showed in the, in regards to the George Floyd Act, and then less than a month later, the Asian hate bill. If those things are not waking us up and making us realize that they are just pretty much just playing with us, then we really need to, we got to open up our eyes. We definitely have to open up our eyes and get the power among us again so that we can stand together. on one accord to not be running to the polls and to not be begging. And, we have to basically demand it and, not be voting and getting nothing in return.
I definitely agree. If you can have people come off a boat, a plane, or by foot and automatically get housing, resources, loans for businesses, and again, haven't been here, let alone 3 months, let alone 245 years, and again just leapfrog our group of people. If that isn't a red flag or eye opener, then I'm not sure what else to tell you. Again, we've shown completely, or time after time, inventions that our group has created that has led to this civilization not only thriving here in the Americas, but also around this world. And again, if we continue to just let people reap the benefits of our creations, of our land, of our resources, while we just stand by idly, it won't be too much standing by idly. It will just be an extinction of our group. So again, I think it's the time for us to stand up as a collective. Again, all great points made by, Chief Alligator as well as Chief Quietwater. And yeah, I mean, we're seeing it in real time. Whether you're in New York, whether you're in Atlanta, Texas, it doesn't matter. You're seeing this, whether it's through gentrification, whether it's through not being able to afford, housing, not having any jobs. I mean, it's everywhere you look. So at this point, it's either we're going to do something about it or we're just going to continue to sit by idly until we're completely wiped out.
And also, just to piggyback on that, the fact that, like we've proven and shown that they have already projected where we are now.
Correct.
And then we're still behind, of course, but like you just said, like in the thumbnail that I used today, the projects and what they're coining as affordable housing, they're just dumping us right back, with these trinkets that look and sound good, but at the same time, it's setting us so far behind. So we have to stop falling for the BS.
Yep. My last point on this subject right here and the definitions that you're looking at is this is why Pan-Africanism is dead. And I'm going to use this myself, and you can use it for anybody who's a scholar who's pumping the belief system, which is an ideology of Pan-Africanism. Think about Pan-Africanism as being in a classroom. When you're in their world and you're in their classroom, they can tell you all about Africa. They can remix the words and say all of us over here are Africans. But when you walk out that classroom and you go into society, that ideology does not meet the reality. Your driver's license say Black. Your birth certificate say Black. Afro-American is not on any of the documents that's attached to you. You bring this right up to their face. If you're telling me in your classroom that I'm Afro-American, why is it in 1968, a week after King died, they define what an Indian is? Show me where Afro-American is defined by this government. See, that shit only works in their classroom. Outside their classroom, they have no leg to stand on because the government has never recognized an Afro-American. So it's just time for us to stop dealing with bunny rabbits laying eggs and tooth fairies coming magically putting money. It's time to stop all this shit. We grown ass adults. Congress of the United States government, you have a group of people that you've unlawfully warred against. You stole their inventions, their lands, their birthright, their heritage. And that group of people is going to be demanding that you recognize them and that you put them back where you found them and where you stole them from, which is the southeast area of Mississippi. Everything east of the Mississippi River, you took unlawfully. You never declared a war, you never beat us head up. You just stole shit. I'm gonna stop right there.
Absolutely. Absolutely. And with that, we'll jump into our readings for today. This week, we have American inventor Madeline M. Turner. It's not a lot about her date of birth or death date, but they do state that she was born and raised in Oakland, California. Shout out to the Bay. And she is credited for creating the juicer. So we have, again, an American woman creating a juicer, which again has led to many industries. I'm pretty sure everybody on Instagram knows somebody who's, whether selling juices or selling some type of product where they're utilizing this machine here. I'm going to see if I can actually blow this up. So as we take a look at this device, this is basically where you would put the fruit. It would pretty much grind and squeeze out all of the liquid. And then, of course, have its exit point where you would have that juice. The patent number is 1180959. Again, that is 1180959. And this was passed on April 25th, 1916. So again, April 25th, 1916, and this is from Madeline M. Turner, and this is for the fruit press. And this is an American born and raised in Oakland, California.
So when you think freshly squeezed orange juice, you gotta, that's us.
Correct.
Yeah.
Correct. And that's exactly what some of her backstory was stating. She was tired of hand squeezing, I think it was oranges in particular. So she was like, okay, let me go ahead and, instead of complaining, let me invent something to make my life easier, and now turn into an industry.
Brilliant mind.
And that's our American inventor for today. With that, I'll jump into this week's Dr. Carter G. Woodson quote. And I believe, were you taking on that, Chief Alligator?
Yeah, I'll jump on it. Let's do number 3.
Number 3, gotcha.
So every week we do Dr. Carter G. Woodson, who's the author and founder of Black History Month, which really should be renamed American History Month. Quote 3, it was well understood that if by teaching of history, the European man could be further assured of his superiority, and the Negro could be made to feel that he had always been a failure, and that the subjection of his will to some other race is necessary, the freedman then would still be a slave. If you can control a man's thinking, you don't have to worry about his actions. When you determine what a man shall think, you do not have to concern yourself about what he will do. Got lucky when I chose this one, but this one goes right back to Pan-Africanism and being in the classroom. When they're controlling our thinking from 5 to 18 years old, and they know that they got us focused on another landmass, and we're not looking at anything that happened during our grandparents' lifetime, which for me would be the civil rights era. That's another graduating class when it comes to history that they know they don't have to worry about, because these people were never told in detail about the civil rights era or the Jim Crow era or the Seminole Wars or the Civil Rebellion era. Y'all understand? So this really explains who sits on those school boards and approves what books will be read across this land. Europeans. So if they're controlling what we learn about American history and put people in places who look like us to teach us about it, you see how the machine keeps going? Because that's another graduating class that's miseducated about history. And they come out worrying about sexualism and all this other bullshit that does not matter. Go ahead, Chief Biko, Chief Quietwater, if y'all want to build on that.
Yeah, that critical race theory, that's definitely something for us all to be knowledgeable about in regards to what they're doing, because they are forcing that like crazy in different states. And it's just literally, not only were they miseducating us, but now they're just wiping the whole existence of our people out. So, again, like you said, the machine keeps going. They're getting real forceful with it now. So we just have to keep that in mind, especially people with school age kids.
Definitely agree. I'm not sure about any other state, but I do believe that they took out Was the civil rights of Martin Luther King in particular in Georgia in regards to being taught in U.S. history. So as Chief Alligator stated earlier, you already are not being taught about the civil, or I would say the Seminole Wars, actually. You're being told a lie in regards to a civil war because the documents state that it was not a war, it was a rebellion. So everything pertaining to this land's history that is being taught is either going to be a lie or a watered down version of it. So again, if we as the adults continue to allow our children to be taught by these Europeans who have constructed this education system to benefit their own offspring, then who are we to blame? If we again are allowing our children to be told this information when they come home from school, don't ask them, what they learn, don't correct anything, just allow it to be, then who is really at fault? So again, it's on the adults for us to teach our history and not allow another group of individuals to teach our children or our history for us. Because we see what has pretty much taken place. You have all these isms as if this, again, is a religion, because basically that's all it is. It's a belief system. You believe this is what happened, but
Right.
what do the actual documents say?
Right. Definitely agreed.
With that, I'll let you go ahead and take the legal definition, Chief Quietwater, then we'll jump back into the document.
Okay, legal definitions. Number 1, American, indigenous to America. Number 2, descendants, one who follows in the bloodline of an ancestor, either lineally or collaterally. Number 3, slavery, a situation in which one person has absolute power over the life, fortune, and liberty of another. Number 4, prisoner of war, a person, usually a soldier, who is captured by or surrenders to the enemy in wartime. Number 5, school, an institution at which instruction is given in a particular discipline. Number 6, education, an enlightening experience. Number 7, recovery, a return to a normal state of health, mind, or strength, the action or process of regaining possession or something stolen or lost. And then the maroon historical points. Number 1 was a person escaping slavery, seeking freedom, or breaking the law. Number 2, providing unity and a strong defense came first. Number 3, maroon leaders were first and foremost military figures. Number 4, maroons established guerrilla warfare, planting sharp sticks in thick grass. And number 5, maroons knew Europeans' enemies' language, defenses, and plans.
Perfect. Go ahead and bring up this document, and we'll jump straight into it. And yeah, we left off on subsection J on the top of this page here. Did you want to start us off there, Chief?
Yeah, so we're still dealing with the powers of secretary. We'll jump right into it. Section J, court enforcement of administrative order upon petition by secretary. The secretary may petition any United States Court of Appeals for the circuit in which discriminatory housing practice is alleged to have occurred, or in which any respondent resides or transacts business, for the enforcement of the order of the administrative law judge, and for appropriate temporary relief or restraining order, by filing in such a court written petition, praying that such order be enforced, and for appropriate temporary relief or restraining order. Yeah, so the secretary can actually deal directly with the circuit for appeals courts. Section 2, the secretary shall file in court with the petition the record in the proceeding. A copy of such petition shall be forthwith transmitted by the clerk of the court to the parties to the proceeding before the administrative law judge. Relief which may be granted upon the filing of a petition under subsection I or J, the court may grant to the petitioner or any other party such temporary relief, restraining order, or other order as the court deems just and proper, affirm, modify, or set aside in whole or in part the order, or remand the order for further proceeding, and enforce such order to the extent that such order is affirmed or modified. So now it's breaking down what the court can do, and we started off reading about what the secretary can do. Secretary got a big responsibility, by the way, because that's at the federal level, and you're talking about complaints for housing coming all across their jurisdiction. She's the one that has to do that work. How many cases probably don't get heard because she's just bombarded? She can only do, I'm pretty sure they got it broke down to a quota per their term. You
Oh,
feel me?
absolutely.
Like,
Yeah.
we'll do 30 per my term. And then it gets into the who you know game. You know, will your case get be made a part of that 30?
Correct. Basically, the A&R game is similar to, you know, what I was stating with, you know, the Ben Crumps. You know, how much noise can this actually make? How much money can we actually make off of, you know, if we want to push this forward as far as changing anything? So like you said, it's definitely a who you know type of thing versus, I think, it actually being probably legitimate.
Exactly. That's definitely for sure. I know for sure in the Atlanta area.
Okay. I'll pick back up. Section 2, any party to the proceeding before the administrative law judge may intervene in the court of appeals. No objection not made before the administrative law judge shall be considered by the court unless the failure or neglect to urge such objection is excused because of extraordinary circumstances. Enforcement decree in absence of petition for review. If no petition for review is filed under subsection I before the expiration of 45 days, after the date the administrative law judge's order is entered, the administrative law judge's findings of fact and order shall be conclusive in connection with any petition for enforcement. That basically goes back to what we were talking about last week. When you go through some type of court proceeding, your life has to be in order because everything is off dates. So they're saying 45 dates after that judge makes his ruling. So that means you got to count business days on your calendar to that 45 date. And you probably want to file it on the front half of that 45, not the back half. That's where a lot of our people tap out with procedures because we're not in order. Point 1, which is filed by the secretary under subsection J after the end of such day, or under subsection M, court enforcement of administrative order upon petition of any person entitled to relief. If before the expiration of 60 days after the date the administrative law judge's order is entered, no petition for review has been filed under subsection I, and the secretary has not sought enforcement of the order under subsection J, any person entitled to relief under the order may petition for a decree enforcing the order in the United States Court of Appeals for the circuit in which the discriminatory housing practice is alleged to have occurred. So again, that will frighten a lot of people in today's world, right? A lot of us are afraid to go to magistrate court, which is like the lowest level, right? Traffic court, magistrate court, state court, superior court. You're talking about appeals and federal district court. Most of us are so scared of the boogeyman, we won't go through this process. It's almost like the Confederate flag and masonry in a way. They'll put something in your face and hope that you're so afraid of it that you won't investigate it and just pull the curtain back and look. And normally that's where the gems lie for our people. I'm gonna say that again. They'll put the boogeyman out there when it comes for masonry or the Confederate flag. But if you look behind it, you'll come to find out it's your shit. But they're gonna scare the everyday person off just with the symbolism.
Yeah, because they know that we're not gonna dig into it, like you said, because most of the time our lives are not in order.
Anything you want to share on that, Chief Biko?
No, I agree with both of you. Like the point you stated earlier, not having our personal lives in order to even have the, delayed gratification to even wait, you know, the amount of days that's being listed within these time frames, 60 days, 45 days, to say, okay, yeah, I'm good over here. I'm going to actually continue to go through this process, so you won't just, dismiss me. I have time today. I think we use that term a lot, but do we actually have time as a group? I don't think so. So,
Which we should.
which we should. But again, what's the reality? People going into work every day, sometimes overtime just to make ends meet. So yeah, as you stated, this is the process. They say, hey, if the secretary doesn't do what they're supposed to do, if the law judge doesn't, then you can appeal, your case, and then that can be pretty much enforced. But if you don't have time for that, then you'll just let it slide to the wayside. So I think that's where they filter a lot of the complaints as well. Who's really about that action?
Yep. So I'll pick up here, entry of decree. The clerk of the Court of Appeals in which a petition for enforcement is filed under subsection L or M shall forthwith enter a decree enforcing the order and shall transmit a copy of such decree to the secretary, the respondent named in the petition, and to any other parties in the proceeding before the administrative law judge. Section O, civil action for enforcement when election is made for such civil action. If an election is made under subsection A, the secretary shall authorize, and not later than 30 days after the election is made, the attorney general shall commence and maintain a civil action on behalf of the aggrieved person in the United States District Court seeking relief under this subsection. Venue for such civil action shall be determined under Chapter 87 of Title 28 United States Code. Section 2. Any aggrieved person with respect to the issues to be determined in the civil action under this subsection may intervene as of right in that civil action. Section 3, in a civil action under this subsection, if the court finds that a discriminatory housing practice has occurred or is about to occur, the court may grant as relief any relief which a court could grant with respect to such discriminatory housing practice in a civil action under Section 813. Any relief so granted that would accrue to an aggrieved person in a civil action commenced by that aggrieved person under Section 813 shall also accrue to that aggrieved person in a civil action under this subsection. If monetary relief is sought for the benefit of an aggrieved person who does not intervene in the civil action, the court shall not award such relief if that aggrieved person has not complied with discovery orders entered by the court. So we're just talking procedure here. One little slight thing I'll throw in, if you've ever been through a court proceeding, you learn quickly who runs the court, especially if you go to the appellate level, whether it be Court of Appeals or Supreme Court. The clerk runs the court. To be more specific, it's going to be the head clerk. She's anybody who's been through a court process understands what I'm saying. When you go above your superior court at your state level, those documents have to be packaged and put together, and it's up to that clerk to sign off and send that information to the higher court. You understand what I'm saying? So these are just basic things that we have to understand. Now, we're not saying that they're not cheating within their system, but as far as how it's supposed to work, these are just basic things, just like Congress makes their law. Stop getting in front of TV, Biden, Obama, calling us Black, Afro-American, and that shit ain't never been defined. So we're not being radical. We just being rational as adults. Like, stop calling us shit that you ain't never defined. I'll do this last section on this page, or I'll finish up this page and let y'all jump in. Where am I at? Section 3? Section P?
Yeah, Section P.
Okay. Attorney's fees. In any administrative proceeding brought under this action, or any court proceeding arising therefrom, or any civil action under Section 812, the administrative law judge or the court, as the case may be, in its discretion, may allow the prevailing party, other than the United States, a reasonable attorney fee and costs. The United States shall be liable for such fees and costs to the extent provided by Section 504 of Title V, United States Code, or by Section 2412 of Title 28 United States Code. So it can either be offset by the government or you can be held liable. Enforcement by, is this a new page or this the last?
This last little section on this page.
Okay. Enforcement by private persons. A civil action, an aggrieved person may commence a civil action in an appropriate United States District Court or State Court not later than 2 years after the occurrence or the termination of an alleged discriminatory housing practice, or the breach of a conciliation agreement entered into under this title, whichever occurs last, to obtain appropriate relief with respect to such discriminatory housing practice or breach. The computation of such 2-year period shall not include any time during which an administrative proceeding under this title was pending with respect to a complaint or charge under this title based upon such discriminatory housing practice. This subparagraph does not apply to actions arising from a breach of a conciliation agreement. An aggrieved person may commence a civil action under this subsection whether or not a complaint has been filed under Section 810 and without regard to the status of any such complaint. But if the secretary or a state or local agency has obtained a conciliation agreement with the consent of an aggrieved person, no action may be filed under this subsection by such aggrieved person with respect to the alleged discriminatory housing practice, which forms the basis for such complaint, except for the purpose of enforcing the terms of such an agreement. So basically, if you want to represent yourself, no other claim can be filed before you attempt to represent yourself, or they're going to shut you down. I'll stop right there and let somebody else pick up. And if y'all want to build on what I just read.
I'll pick up. I think that was pretty to the point. What about you, Chief Biko?
No, I feel the same. Kind of sounded like an escape clause as well. No action may be filed under this subsection by such aggrieved person with respect to the alleged discriminatory housing practice. So basically, what Chief Alligator was just reading, them saying that, hey, if this doesn't, qualify, if this action isn't taken, then like you stated, it was pretty much the buck stops here.
Yeah. Okay. Section 3, an aggrieved person may not commence a civil action under this subsection with respect to an alleged discriminatory housing practice, which forms the basis of a charge issued by the secretary if an administrative law judge has commenced a hearing on the record under the title with respect to such charge. Okay. B, appointment of attorney by court. Upon application by a person alleging a discriminatory housing practice or a person against whom such a practice is alleged, the court may 1, appoint an attorney for such person, or 2, authorize the commencement or continuation of a civil action under subsection A without the payment, of fee, without the payment of fees, costs, or security, if, in the opinion of the court, such person is financially unable to bear the cost of such action. So it sounds like they're giving them a little grace if they can't afford it, or if they can't afford an attorney. C, relief which may be granted. 1, in a civil action under subsection A, if the court finds that a discriminatory housing practice has occurred or is about to occur, the court may award to the plaintiff actual and punitive damages, and subject to subsection D, may grant as relief as the court deem appropriate any permanent or temporary injunction, temporary restraining order, or other order, including an order enjoining the defendant from engaging in such practice or ordering such affirmative action as may be appropriate. Okay. 2, in a civil action under subsection A, the court in its discretion may allow the prevailing party other than the United States a reasonable attorney's fee and cost. The United States shall be liable for such fees and costs to the same extent as a private person. Okay. What is that saying? In the civil action under subsection A, the court is in discretion may allow the prevailing, okay, so the winning party other than the United States a reasonable attorney fees. Okay, so I guess whoever wins, they can be granted attorney fees and costs. Is that what that's saying? Am I reading that right, understanding it?
Yeah, that's what I'm
Okay.
getting to. Yeah, especially
Okay.
with that prevailing party. Mhm.
Mm-hmm. Okay, D, effect on certain sales, encumbrances, and rentals. Relief granted under this section shall not affect any contract, sale, encumbrance, or lease consummated before the granting of such relief and involving a bona fide purchaser, encumbrancer, or tenant without actual notice of the filing of a complaint with the secretary or civil action under this title. So basically, let me see, effect on certain sales and rentals. So I guess if things have already been in motion, like if a contract has been solidified or a sale, uh, y'all help me out with this one.
Yeah, you asked out, effect on certain sales, encumbrances, and rentals. Relief granted under this section shall not
Not affect.
any contract, sale, encumbrance, or lease.
Gotcha.
So even if you felt like you got discriminated against, it still ain't gonna stop the fact that you got 60 days to move out.
Mm-hmm. Right, okay. E, intervention by Attorney General. Upon timely application, the Attorney General may intervene in such civil action if the Attorney General certifies that the case is of general public importance. Upon such intervention, the Attorney General may obtain such relief as would be available to the Attorney General under Section 814E in a civil action to which such sections apply. So basically, I guess if it's escalated up to the Attorney General, it got to be something really, really serious that the secretary probably can't handle.
Right, and just going back to what you said on Section D, this really explains how you can move a group of people out of an area and not really have to worry about any type of penalties coming from discriminatory housing practices, because it's not going to stop you from selling the property, right?
Right.
It's back to a group of people going through the court process to get a judgment in their favor.
Mm-hmm.
If you're going to get a judgment in your favor because secretaries overworked and underpaid at the federal level, I'm sure there's a lot of, so they got the people who own, the people who playing landlord, they know that there's a lot in their favor for them to get caught up and have to pay a stupid tax for doing discriminatory practices. What's the chance that your case is one of those cases that the secretary is going to take?
Mm-hmm.
And then what's the chance that you can't settle outside of court behind the scenes with the administrative law judge or the secretary at the federal level to get the shit thrown out?
Right.
That's the way the game is played. Most of the
Mm-hmm.
time on the owner side of the ledger, it's all about a dumb tax. Okay, I made a mistake. Somebody wants to actually take me up through there. How much I got to pay to get out this situation? That's really
Right. Okay, you got anything, Chief Biko?
Nah, I'm in line with everything you guys said.
Okay. Enforcement by the Attorney General, Section 814, a pattern or practice cases whenever the Attorney General has reasonable cause to believe that any person or group of persons is engaged in a pattern or practice of resistance to the full enjoyment of any rights granted by this title, or that any group or persons have been denied any of the rights granted by this title, and such denial raises an issue of general public important, the Attorney General may commence a civil action in any appropriate United States District Court. So basically, I guess if there is a pattern of a particular type of action towards someone, then they will step in to commence a civil action in the appropriate court. So B, on referral of discriminatory housing practices or conciliation agreement for enforcement. 1A, the Attorney General may commence a civil action in an appropriate United States District Court for appropriate relief with respect to a discriminatory housing practice referred to the Attorney General by the Secretary under Section 810G. B, a civil action under this paragraph may be commenced not later than the expiration of 18 months after the date of the occurrence or the termination of the alleged discriminatory housing practice. Again, got dates and deadlines that we have to abide by. So 2A, the Attorney General may commence a civil action in any appropriate United States District Court for appropriate relief with respect to breach of a conciliation agreement referred to the Attorney General by the state under Section 810C. B, a civil action may be commenced under this paragraph not later than 90 days after the referral of the alleged breach under Section 810C. C, enforcements of subpoenas. The Attorney General, on behalf of the Secretary or other party at whose request a subpoena is issued under this title, may enforce such subpoena in appropriate proceedings in the United States District Court for the district in which the person to whom the subpoena was addressed resides, was served, or transacts business. Okay, so basically the Attorney General enforces the subpoenas. D, relief which may be granted in civil actions under subsections A and B. 1, in a civil action under subsection A or B, the court A may award such preventive relief, including a permanent or temporary injunction, restraining order, or other order against the person responsible for a violation of this title, as is necessary to assure the full enjoyment of the rights granted by this title. B, may award such other relief as the court deems appropriate, including monetary damages to persons aggrieved. And C, may vindicate the public interest, assess a civil penalty against the respondent in an amount not exceeding $50,000 for the first violation, and the amount not exceeding $100,000 for a subsequent violation. So basically, it's just outlining the penalties that will be imposed. You guys have anything on this?
No, correct. Just basically laying out the procedures. The ones you was reading prior was those for the Attorney General as far as their powers, what they are responsible for, or what they can and can't do. And now you're looking at the penalties, and again, not exceeding certain violations. So kind of going back to your point, Chief Alligator, in regards to, I'll say, like these big companies or these major landlords, it's like, okay, what's the penalty that I have to pay?
Mm-hmm.
Okay, cool. Now go ahead and dismiss that. What's 50,000 to somebody making billions off a group of people?
Right.
I got an idea just outside the box. If we've never been defined, or if the definition of who we are has been used by another group of people, right? But when we look at documentation from this government or on this land, when it comes to wars being fought lawfully or unlawfully, and inventions that came from the people on this land, if we've never been defined by this government as a group of people, wouldn't that make us above any laws that they've created? Because in other words, if we've never been a part of the equation, then we're not a part. It's like algebra, right? What happens on one side of the equal sign got to happen on the other side of the equal sign, right? If we're not in the equation on the left side of the equal sign, how the fuck we gonna come out on the right side?
Right.
So this really may play into our favor. I'm just throwing this out there. If we're trying to be recognized 246 years later after this shit has existed, is it safe to say that everything that's been done to us by this government has been unlawful?
Yeah, for sure.
Because you've
absolutely.
never recognized us. So
Right.
that plays in our favor. I just wanted to throw that on the wall and see what y'all got to say about that. Or
Yeah,
the
that
chat.
makes perfect sense.
No, I'd
Okay.
agree. I'd agree. Yes, you don't have any jurisdiction, like you stated. We're not under this law because we've never been defined within it. So we're outside and pretty much surrounding it. So anything that is pertaining to these laws really wouldn't pertain to us because we never been defined within these laws.
Right.
Right. And we hear it all the time on police radios when they show us videos of our killings. They'll say black male, 6'2", 180 pounds. Okay. What's the definition of black at the federal level?
Mhm.
Ooh. So everybody that you're calling black, your government doesn't even define what black is.
Mm-hmm.
So how are you going to, I'm just thinking outside the box. If you're not a part of the equation on the left side of the equal sign, how are you going to come out on the right side of the equal sign, y'all?
Valid. That's a good way to look at it. Easy way to break it down.
If anybody in the chat has an idea, we're trying to solve something that we've never been included in.
Mm-hmm.
At the federal level, we've never
Right.
been defined as a group of people. So is it safe to say that we define who we are? This government needs to recognize us, and this government, in the process of repairing this group of people who are the American, the real American, you assist us just like you did the Jews in Israel with our own government.
Right.
And the first thing we got to have is defense. If we ain't learned nothing else from the last 246 years, before you build any department, you better have a Department of Defense. I think we've seen enough towns flooded, burned,
Right.
enough niggas running from the South, running to the North to know you better have protection. I'm gonna stop right there.
Absolutely. Okay, I'll go. Okay, number 2. In a civil action under this section, the court, in its discretion, may allow the prevailing party other than the United States a reasonable attorney's fee and cost. The United States shall be liable for such fees and costs to the extent provided by Section 2412 of Title 28 United States Code. E, intervention in civil cases, intervention in civil actions. Upon timely application, any person may intervene in a civil action commenced by the Attorney General under subsection A or B, which involves an alleged discriminatory housing practice with respect to which such person is an aggrieved person, or a conciliation agreement to which such person is a party. The court may grant such appropriate relief to any such intervening party as it is authorized to be granted to a plaintiff in a civil action under Section 813. All right. Okay, section. Oh.
I'm about to say I could pick up here if you want.
Okay, cool.
So we got section 814A, incentives for self-testing and self-correction, privileged information, conditions for privilege, a report or result of a self-test, as that term is defined by regulation of the secretary, shall be considered to be privileged under paragraph 2 if any person conducts or authorizes an independent third party to conduct a self-test of any aspect of a residential real estate related lending transaction of that person or any part of that transaction in order to determine the level of effectiveness of compliance with this title by the person, and has identified any possible violation of this title by that person and has taken or is taking appropriate corrective action to address any such possible violation. I'll just stop right here and kind of say what I took away from this is basically being able to, your appeal will first go through us first to see if we did any action. So kind of like when it comes to like any NFL procedure, there'll be an in-house investigation that'll take place. So we're not looking for any outside parties. So when they say self-test, getting that these landlords will first test to see if they are actually being discriminatory. So they're going to test themselves to see if, hey, am I being discriminatory? And if so, then I can go ahead and start making these quasi-corrective actions that'll pretty much dismiss any type of discriminatory claim. That's what I'm getting from these first two subsections. Anybody want to bid off that, or are we good?
Yeah, you good on mine.
I'm good.
Okay.
Yeah.
So we got number 2, privilege self-test. If a person meets the conditions specified in subparagraphs A and B of paragraph 1 with respect to a self-test described in that paragraph, any report or results of that self-test shall be privileged and may not be obtained or used by any applicant, department, or agency in any proceedings or civil action in which one or more violation of this title are alleged, or examination or investigation relating to compliance with this title. So after they've done their self-test, when they state privilege, that means that they are the only ones that will have access. So it's saying not only will the complaining party not have access to it, but any agency or any department won't have access to this as well. So again, just being able to self-assess themselves as far as these landlords or these, owners of these housing places. And again, stopping the ball at where it's at, saying, hey, we've made our corrective action, so there won't be any need for any further court appeals or any further proceedings. So we have here results of self-testing in general. No provision of this section may be construed to prevent an aggrieved person, complaint, department, or agency from obtaining or using a report or results of a self-test, of any self-test in any proceeding or civil action in which a violation of this title is alleged, or in any examination or investigation of compliance with this title, if the person to whom the self-test relates or any person with lawful access to the report or the results voluntarily releases or discloses all or any part of the report or results to the aggrieved person, complaint, department, or agency, or to the general public, or refers to or describes the report or results as a defense to discharge of violations of this title against the person to whom the self-test relates, or the report or results are sought in conjunction with an adjudication or admission of a violation of this title for the sole purpose of determining an appropriate penalty or remedy. So again, it's still giving the power to the people having this self-test, because it's stating that unless they voluntarily release it, unless they, are referring to any self-reporting within any type of, I would say, court procedure, or if they are using it to pretty much defend themselves in any appeal or case that is, I guess, conjunctive to what they pretty much stated or what they found in that self-report, they'll be able to release it. But again, it's not seeing that there's any power unless that privileged self-testing party is willing to give up that information. At least that's what I'm getting from these subsections. Anything on that, or y'all good? No,
Okay, it's an in-house game, basically. It's an in-house game. I'm just sitting here thinking right now, in relationship to the General Order 3, 4, and 5 we did about Juneteenth, where we can see that once the military comes in and occupies a certain area, over time, the United States government is able to come in and start reaping percentages of income from all the resources in that area. As we finish up this document, which we should be able to finish it up today, we got some questions we got to ask ourselves while we're exposing lies. 13th, 14th, and 15th Amendment, the lie is told that there was a civil war and the United States government made the 13th, 14th, and 15th Amendment. Where that story doesn't make sense is, why the fuck are we reading Civil Rights Acts from 1964, 65, and 68? If we had the right to vote through the 14th Amendment or the 15th Amendment, why did Lyndon Baines Johnson have to come back in 1965 and give a right to vote? In that period of time, what would that classify us as? I'm asking the people that's listening to this video that are in the chat, I'm asking a serious question. I want an adult answer. The window between 1865 to 1965, what do you call that group of people who in the 1960s had to have a desegregation act, a voting rights act, and then in 1968, they did an Indian rights? What are those group of people? You can't be citizens.
Exactly.
So let's think about everything that happened to us in that 100-year period.
And this is basic. I mean, this is just blatant, right in your face. Like, that is a question that people have to think about. Why would we have to have those civil rights acts passed if we were citizens.
Correct.
So,
And if we're not citizens, what would you call that? The best I could come up with is prisoner of war. That's the only type of person that can be hung from a tree, put on a postcard through
right.
the post office, and you could legally buy that anywhere in what we call the United States of America.
Yeah.
So I'm just asking all the adults who have kids, and we're just showing the difference in why are we never taught the civil rights in detail in school?
Mhm.
And to those people who do history or study history, what's your explanation for telling us that we're African American, but when we come out your classroom and put the 1968 Indian Rights Act in your face and say, where's the definition of Afro-American, like the definition of Indian is described, y'all ain't got nothing to say. So why are you so adamant about making us be something that this government's never recognized?
Exactly.
I'm gonna stop right
And
there.
it sounds like everybody in the chat is on board. Everybody is saying, a few people are saying prisoners of war, which is, I mean, it's obvious. You know what I'm saying? Just to be able to read these documents and understand them. It's the fact that we never read them. So this information, we would have never known if we didn't just break all of this stuff down, in regards to just actually reading the Civil Rights Act,
Right. No, I definitely agree with that. Going back to what the video said at the top of the actual program, on the top of the live, an Emancipation Proclamation is not fact. That's coming from their own president, stating that, again, if that 13th through 14th or 13th through 15th amendment was supposed to apply to us, then why the hell do we need, again, a 1964, 65, and 68 Civil Rights Act? And as stated before, what do you call that period? I think we showed on Friday just another proof of claim, another file within our case that we are prisoners of war. It stated that all persons that are unwilling to comply with what that general order, in particular General Order number 4, stated, will basically be prisoners of war, shipped up north, and all of your resources, everything that you had, will be confiscated. Basically now property of the United States. So we keep coming across these documents, the more that we read them, and it just further proves what we've been saying, which is, we're prisoners of war and prisoners of unlawful wars. Because it's stated, nobody's ever said, hey, we're going to fight you at, 6 o'clock in the schoolyard. That's never happened. It's just been continued acts of, again, hangings, whether it be, lynchings on postcards or somebody getting choked out on a subway. And it's continuing to happen. So at this point, yeah, what other term would we be using outside of that? Because again, if you have, these scholars that are supposed to be saying we're African American, why would we want to be something that is not representative or does not exist within this system?
Right. I think that's the biggest thing, that I think if we can wrap that around our brains, everything else is a piece of cake.
Absolutely. 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 With that, I'll go ahead and continue on section 2, disclosure for determination of penalty or remedy. Any report or results of a self-test that are disclosed for the purpose specified in paragraphs 1B shall be used only for the particular proceeding in which the adjudication or admission referred to in paragraph 1B is made, and may not be used in any other action or proceeding. So whatever is basically being disclosed by the self-test, I guess you could say persons, self-testing persons, any information that is disclosed in a particular case cannot be used in another case. So I guess similar to no double jeopardy type of thing. Let me see here. Subsection C, adjudication, an aggrieved person, complainant, department, or agency that challenges a privilege asserted under this section may seek a determination of the existence and application of that privilege in a court of competent jurisdiction or an administrative law proceeding with appropriate jurisdiction. Now we have rules to implement title. Section 815, the secretary may make rules, including rules for the collection, maintenance, and analysis of appropriate data. To carry out this title, the secretary shall give public notice and opportunity for comment with respect to all rules made under this section. Effect on state laws, section 816. Nothing in this title shall be construed to invalidate or limit any law of a state or political subdivision of a state or of any jurisdiction, any other jurisdiction in which this title shall be effective, that grants, guarantees, or protects the same rights that are granted by this title. But any law of a state, a political subdivision, or other such jurisdiction that purports to require or permit any action that would be discriminatory housing practice under this law shall, to that extent, be invalid. So basically anything on a state level or local level that's contradicting what is being said within this fair housing practice is going to be null and void. Cooperation with state and local agencies administering fair housing laws. The secretary may cooperate with state and local agencies charged with the administration of state and local fair housing laws, and with the consent of such agencies, utilize the services of such agencies, their employees, and notwithstanding any other provision of law, may reimburse such agencies and their employees for services rendered to assist with or assist him in carrying out this title. In furtherance of such cooperative efforts, the secretary may enter into written agreement with such state or local agencies. All agreements and terminations thereof shall be published in the Federal Registration. So again, going back to, I think what you said there, Chief Alligator, just a lot of money grab. What we're seeing is here, local agencies. So that could just be a regular business saying, hey, we help out in, identifying unfair housing practices. So secretary, come work with us, pay our people, and we'll help, get the job done. And that's also on the state level as well. So you not only have your local government, but you have local, I guess you could say, I wouldn't say 501c3s or anything like that, but possibly just organizations or governments or organizations rather that have nothing to do with the government helping out and again, getting paid for their services here.
Well, it's also a scam on one, going back to POW status, right? Congress makes their law. We're reading the 1968 Civil Rights Act. Negro, Black, colored, or Afro-American was never defined, only Indian. And what an Indian court, tribe, and an Indian and a self-government is for Indian. But Black, Negro, colored, Afro-Americans never been defined in law. However, by proxy, we come up under the United States government's jurisdiction when it comes to housing. Y'all see that?
And that's pretty much to keep us in our place.
Right. You're not defined in law, but we're going to get jurisdiction through your housing. Because remember, the European peasant that was coming from Europe, coming through Ellis Island, he rubbing his hands together because he already know the United States government got him. Remember, they were in the ghettos first. What you call Jews today were in the ghettos and the housing projects first. Look that up while we're online. They don't hide it. Jews were in the ghetto first. So when they came on that boat across that Atlantic Ocean, which we're told we were part of the slave trade, but it's very interesting that none of the Pan-Africanists ever take into account how many Europeans came across the Atlantic on ships into Ellis Island. They knew they were coming into housing. Right in New York.
Goes back to what we read in the general order. Freedmen, stay in your housing and work for reasonable wages. So I mean, it rhymes perfectly with what we've been showing throughout our time on this channel.
Right.
Go ahead, there, Chief Alligator. I didn't mean to stop you, Bill, but just thought about that.
No, I'm just looking at. We're trying to solve a problem for a group of people. If you've never been defined in their law, then look at what they're doing in the 1968 Indian Rights Act. They knew that they were fucking us over. Correct?
Correct.
For sure.
They sat down in a think tank. Lyndon Baines Johnson and whoever was in office with him. Think about it. Put yourself on their side of the coin. How do we're getting a lot of pressure around the world because the world saw us do what we did in Selma, Alabama. The world is watching us now through TV, you know, with the onslaught and the attacks with the KKK and the Jim Crow South. How do we calm this shit down? And we done finally pulled the trigger on MLK a week ago. So that week after they killed MLK, they were like, how do we get these niggas out the street? We're gonna have to do a ritual through our Congress. Here go the dirty part though. I'm finna say this because it's the facts. They also gathered the niggas up who was fighting for us and told them this gonna be the play, y'all. In other words, everybody was in on it because you went through 12 years of school and nobody ever showed you the 68 Civil Rights Act. So this ain't hard to understand that people who look like us were down with fucking us.
Yeah, that's
Can
definitely.
we all agree on
evident.
that? Can we
Right.
all that part?
I definitely agree with that. That's evident.
So part of their plan was we were never supposed to do this for probably another 100 years. If you think about it, like these niggas will never think to read the act after King. You know what you do when Martin Luther King comes up? We'll give him a holiday. We'll recognize a national holiday for him. Only show their people in school or through media when it's time to celebrate his birthday. Only show little nitpicks of him marching and dogs and police beating them. Never show them the actual documents. That's as simple as they did it when they organized.
And ain't that funny how, you know, once they, and I'm gonna use this term, kill a nigga, we'll say, okay, now let's give him a holiday.
Right. I was just about to say that with George
You know,
Floyd. Yeah.
George
yeah.
Floyd, you know, so
Yeah.
we'll
And we
recognize
accept
him.
it.
Exactly. We'll recognize him as a holiday again, so we can get federal time off or get federal paid, you know, holiday or leave or whatever you want to call it. But as far as what MLK is, as far as his group, we're not going to recognize him. We'll recognize the idea of MLK, so we'll give him a holiday. And now we see, you know, 60 years later, basically, or close to 60 years later, same thing with George Floyd. We're not going to give them protection, but we'll give them a holiday. Let's make it something around, you know, this Juneteenth thing, since, you know, they automatically think that they are the slave. Again, not recognizing the actual general order or any special field order, but, you know, the idea of it. Let's recognize that. So again, we can still reap benefit off them as well, and then go from there. Just give them something to quiet down. They've been in the streets going crazy. Let's give them a holiday. Same thing happened in April 4th or April 11th, rather, in regards to signing of this act.
Yeah.
All right, let's see if we can finish. We will be finishing this document tonight.
Sure.
This has been our longest document to date. I don't want to stop your bill, Chief Biko. Let's go ahead and finish strong tonight on the 1968 Civil Rights Act.
Let's get it. Interference, coercion, or intimidation, Section 818. It shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on account of his having exercised or enjoyed, or on account of his having aided, or encouraged any other person in the exercise or enjoyment of any right granted or protected by Section 803, 804, 805, or 806. Let me see here. Appropriation, Section 819. They are hereby authorized to be appropriated such sums as are necessary to carry out the purposes of this title. Separability of provisions, 820. If any provision of this title or the application thereof to any person or circumstances is held invalid, the remainder of the title and the application of the provision to other persons not similarly situated or to other circumstances shall not be affected thereby. Title 9, Prevention or of Intimidation in Fair Housing Cases, Section 901. Whoever, whether or not acting under color of law, by force or threat, of force willfully injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person because of his race, color, religion, sex, handicap, as such term is defined in section 802. Again, another definition of what handicap is. Familial status, as such term is defined in section 802 of this act. Again, another definition. Or national origin, and because he is or has been selling, purchasing, renting, financing, occupying, or contracting, or negotiating for the sale, purchase, rental, financing, or occupation of any dwelling, or applying for or participating in any service, organization, or facility relating to the business of selling or renting dwellings, or any person because he is or has been, or in order to intimidate such person or any person of any class or persons from. So we have 1, participating without discrimination on account of race, color, religion, sex, handicap, as such term is defined in section 802 of this act. Familial status, as such term is defined in section 802 of this act. Or national origin in any of the activities, services, organizations, or facilities described in section 901A, or affording another person or class of person opportunity or protection so to participate, or any citizen because he is or has been, or in order to discourage such citizen or any other citizen from lawfully aiding or encouraging other persons to participate without discrimination on account of race, color, religion, sex, handicap, familial status, or national origin in any of the activities, services, organizations, or facilities described in section 901A, or participating lawfully in speech or peaceful assembly, opposing any denial of the opportunity to so participate, shall be fined under Title 18 United States Code, or imprisoned not more than 1 year, or both, and if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under Title 18 United States Code, or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under Title 18 United States Code, or imprisoned for any term of years for life, any term of years, or for life, or both. So again, just a lot of pretty much just going actually over Title 9. But again, I would say that none of that stuff pertains to our group. Because how many times have we heard about bombings, fires being put in front of people's houses, lit, crosses, all kind of shit.
Exactly. Bombs
And
thrown through windows.
exactly. And all because they didn't want you living in a particular neighborhood or just didn't
Right.
like you. So I would say all of this is, yeah, it's fine as far as wordplay, but in reality, none of that actually as far as was enforced, at least not for our group. And lastly, Title X or Title 10, Civil Obedience, short title, Section 1001. This title may be cited as the Civil Obedience Act in 1968. Criminal penalties for acts committed in civil disorder, Section 1002, amends Title 18 United States Code by inserting a new chapter 12, Civil Disorders, amends the table of contents on Part 1, Crimes of Title 18 United States Code. And that is the end of the 1968 Civil Rights Act, also known as the Indian Rights Act.
Congratulations to everybody that has been rocking with us. This has been our longest lawful document. There's a couple of bullet points that I want to cite to. If you want to just make mental note, if you can scroll back up, Chief Biko, to that previous section and do your quick right there and scroll down a little bit. And if you can highlight where it says race, color, religion, sex, handicap. This is a point that we need to take out of this document as the people who descend or had grandparents that was in the civil rights movement, the Negro. The same fictional group of people that the president got in front of the TV and spoke on 1968. What we now know after reading this document, Negro, Black, colored, and Afro-American were not defined and not written nowhere in this act, but who they did include, they included race, color, religion, sex, and handicap. Do you see the finesse game? Look at each one of these terms as an accounting term. Remember, our grandparents were getting churches bombed, dogs sicked on them, boycotting for a year, but we didn't specifically benefit. They made it a race thing. They made it a color thing. They made it a religious thing. They made it a sexual thing, and they made it a handicap thing. That's one point we got to take out of this. The second point, can you do your quick find for the definition of family? Earlier in this act, where it defined the lawful definition of what they consider to be a family. This is also key because they define family as one person. There's a section in here where it defines family. You may have to, so not only did they not specifically identify the group of people that they were warring against, what we like to do, or what our people like to do through the school system, is they like to use the words that were given them, like Jim Crow, segregation. What we're actually saying is Jim Crow and segregation are fancy terms for prisoners of war. What else would you call a group of people that could not cross the line? Don't cross the gun line, boss. That's basically what we were. We couldn't cross the gun line. We crossed the gun line, you can get your brains blowed out in front of a restaurant, and no sheriff and no police is going to arrest that man for murder. That sounds like theater of war to me. So here we see the lawful definition of family includes a single individual. This is how they finessed our women to come up under the federal government housing. No disrespect to our women. We're just looking at how they fucked us. They never specifically included us. And then they turned around and came up with their own lawful definition of family. And we went for it. Again, we have to consent to what they are doing. All of this is mental. And the most pivotal point, if well, y'all want to build on that right quick, just the definition of family and how they went from not defining Negro, Black, colored, or Afro-American, but included race and all that other stuff?
I mean, for me, it's so simple to understand and where we stand, you know, as a group of people. It's clear, you know, we just have to take this information and do something with it. But like you said, not being defined, and here we have family, including just a single individual, which omits the man from the family structure. You know, it was just detriment to us, period. You know, that's when things start to fall apart. So I just think that people just need to understand that, as we said in the beginning, we have to start first with them, us telling them how we want to be defined within this structure or outside of the structure, to be honest. So I think that's what I'm taking from this.
Absolutely. I think it goes back to what you stated earlier too, Chief Quietwater, in regards to all of this stuff was planned in years in advance. So although this is a 1968 Civil Rights Act, when they came up with this term to include a single individual, they was, you know, thinking with, you know, foresight. Okay, once we make sure that we split up the family and make it almost a necessity for the women to come to us and basically be the father figure, or basically come to us for resources, this is when we'll have them. So we need to make sure that we are including a single individual, since that is in our plans to have the woman come with just the children, not the man, and be living in these housing projects, these housing authorities and stuff like that. So all of this stuff, you know, is playing years in ahead, and now we're seeing the repercussions of that, whether it's through your, you know, rap music from the 90s, 80s, all the way till now, you know, where we talking about, you know, we don't need, you know, such and such and things of that nature. And again, that's just the surface. That's just, you know, the surface level of it. Haven't even gotten into the deep portions of you're not even being accounted for to even give resources. So that's what I took away from it.
Let's add one more thing on that. There's a Vietnam War going on. That was the first war that people were coming back, and the women that had kids from these soldiers were able to get benefits. See, your family members, see women that had babies from men that went to World War II, Korean War, and World War I, you didn't get any benefits from your family member dying in war. Don't forget that, because you weren't a citizen. So look at the generations up until this 1968. They're in the middle of Vietnam War. Those are the first of our men that went and fought for this government, that if they died, the woman may receive something, but that wasn't the case for the Korean War, World War II, or World War I.
And Chief, just to kind of add, you know, some toppings on top of that, the Vietnam War was never declared. So we have our men being sent out to fight a undeclared war. And so now you have, you know, the families of, you know, these fallen soldiers not get benefits. And it's, well, we really can't give you benefits because we never really declared a war. So you see how it's almost like they have us both ways as far as like a catch-22. So we'll say it's a war, send off these niggas to fight. Okay, we know it never declared war, so when they die, we ain't got to worry about giving, you know, their families any benefits because we never declared it in the first place. Again, we highlighted that, you know, how many times did Congress declare war? It's a reason why Congress needs to declare war, because he won't have anything coming off of that on the back end. Is exactly. So exactly all of these things he stated, yeah, they'll say it's a war, but in actuality, what do the documents say? So I just wanted to add that point too.
Right. And think about what it puts the woman in if her man did go to Vietnam and came back, but she's got this federal housing. Now she's living in Marcy projects. I'm just going to give that example because it just came to my mind. Now there's an internal conflict with that woman who has that soldier's kids, because now she has to tell them, based on federal housing rules, you can't be here. So here this man done fought and killed in Vietnam War. He's not getting military benefits, and he can't even come back home to be with his wife and kids, because for her to keep the housing benefits, she's head of household, he can't be there. So again, we're just looking back at what happened. We're not blaming our grandmas or our aunties and uncles. We're just looking back at how the government was able to fuck us. And shout out to Muhammad Ali for saying, I ain't going to your war. Shout out to the Jim Browns of the world. Shout out to the Kareem Abdul-Jabbars of the world. My, how we forget people who stood up in that era. You see what I'm saying? That man was heavyweight champion of the world, but that man stood on principle. You segregating me in my own land. What the hell you think I'm finna go cross the water for and fight? A lot of our men didn't have that choice because they were drafted.
Yeah.
Correct.
They forced us to fight for something that we were never to be a part of. Y'all want to add on that?
Go ahead, Chief Coldwater.
Yeah, that's definitely true. There were a few select few people that did stand up and made a stand, you know, in a statement in regards to exactly what we're talking about. I just really think that what happened, like you said, we're not blaming anyone, but there was just a major divide with our family right here at this point in time, which, even though they forecasted all of this stuff to happen, but right here, there was a great divide with our family. Like you said, the men coming back from war, a lot of them, you know, went homeless. A lot of them had mental things going on, and they had no home to come back to. And so it really broke down the family structure from us at this point. And now here we are, X amount of years now in, in the future, and it's a circus. So it's so many pieces to the puzzle that we have to fix. But again, our point that we're making is going back to the beginning. First, we have to be defined, and we have to demand that, we set forth what we want and we stand on it. We're not begging, we're not asking for any of those things. We need to stand strong as a united front and take what's ours.
Absolutely. Absolutely. I mean, shit, a perfect example of what, Chief Quietwater and Chief Alligator just highlighted, especially in regards to the Vietnam War. I mean, pretty sure a lot of people in the chat familiar with dead presidents. That's the exact goddamn scenario in which he described. Somebody coming back home from the Vietnam War, not able to find steady work, their woman and family set up in a project, and he can't even live there. Or if he does, then now that resource is no longer available for his woman and family. So again, that's just, on an entertainment basis, but still is relevant to the topic, because that's a similar story that was pretty much took place for a lot of the men of our group. So I definitely just want to highlight that. And again, just going back to the definition part, again, yeah, we have to be able to define who we are and tell them this is who we are. Hell, you got these motherfuckers now claiming to be anything they want to be. The man can be the woman. Hell, you can be, black if you want, Asian if you want. So again, we's talking about reality, and yet they're talking about, yeah, well, I feel like I'm this. And, the masses just say, well, if that's how they feel, we should go along with it. When we're showing you actual documents and presenting the whole case to say, no, this is not how we feel we are. This is who we are. And we are going to be defined as such. So I think that's just, again, the foundation. Have to define who we are, tell this government, this is who we are. If you plan on getting any type of resources, any type of energy from our group, you need to write this definition into your laws, and then that is where we'll have a discussion. If that is not on the table, then there's no point of even talking. And I think that's exactly where we need to be at with it.
Right. So we'll go to the last point. We've done 2 points. First point, they added sex, religion, and other classifications to something that our people actually fought and died for. The second point, they redefine what a family is by making it a single individual. And we're going to go to the last point and the most important point. If you can go back to Title II and the definition of Indian. This kills Pan-Africanism right here, y'all. This is the only thing we need to be citing to with Pan-Africanists. What page is this in the 1968 Civil Rights Act?
Page 2.
Page 2. This is what all of us need to do. Anybody who comes with the ideology of Pan-Africanism, we need to say, okay, that shit sounds good in your classroom at the high school or collegiate level. However, when we come outside that classroom, Afro-American has never been lawfully defined by Congress. Here's a group of people that has been. So until Afro-American gets defined by Congress, why the fuck are you telling me I'm Afro-American? It's just that simple. That's where we need to be with the belief system of Pan-Africanism. Don't ask me to call myself something that the government has never defined or recognized. It's a belief system. We all need to know page 2 of the 1968 Civil Rights Act, put this in a Pan-African scholar's face and say, where is the definition of Afro-American or African-American? Through Congress, through this government. If you cannot show that to me, why are you trying to make me call myself something that this government does not recognize? Anything y'all want to say on that? That shit dead.
Yeah, it's pretty clear. I think you hit it on the head.
And I think we leave it at that. Again, going back to the document, yeah, you can call all this shit that you want, but if you want to continue to be non-existent by this government, then yeah, you can go ahead with your African American term, your black, Negro, colored, etc. Now the people of color, and just be lumped in with everything and still not be specified or allocated towards, then yeah, that's your prerogative. Go ahead. But the rest of us, nah. We understand what the fuck is going on. We understand what these documents are saying, and we understand that this government will define and specify pretty much any and every damn thing. So why is that not a part of the agenda when it comes to our group?
Does anybody in the chat feel differently? If you feel differently, as we just closed out that document, feel free to voice your opinion in the chat, because we're just solving a problem, keeping it as simple as possible. You're not going to tell us that we're something that this government has not recognized. In addition to that, neither has Black, colored, or Negro. So the same way that you set up, let's be honest, the real Cherokee, what we've also shown on this channel via law, via treaties, and via the government, the 5 civilized tribes, the people that are the original people of those names, they come from east of the Mississippi River. That's a fact. So the only group of people that's not taxed per this government is the Indian. We are the Indian, and we have to claim that name. There's no reason why we should be paying tax to a government that waged unlawful war on us, Jim Crowed us, mass incarcerated us, miseducated us. Come on. We ain't saying that people, hey, immigrants, y'all want to come over here, y'all want to be US citizens, have at it. But there is a group of people on this land that should not be taxed. The same people that you get your music from, the same people that you get your lawnmower and your automobile and your transmission and your telephone and your trains, that people. The same people, the same people that gave you rock and roll, blues, jazz, rap music, the guitar, the microphone, that group of people don't pay tax to the United States government. Actually, they should be paying tax to us, a perpetual tax. You can never get out of debt for what you've done. But it's got to be enough of us that understand who we are and willing to stand on that. It is what it is. Everybody got to pay a fee around the world. If I built the bike from scratch, just because a group of other people came in our neighborhood and stole 3 or 4 bikes, it's my bike. So when I get my clique to come back to your neighborhood and get my shit back, there is no negotiation. If you still want to use my bike, if I'm nice enough to let you use it, you can probably use it while we playing basketball or throw up tackle or something like that. I don't understand what we're not understanding about this. This is our shit. Everything we use today is our shit. It's just time to claim it and take it back. It's just that simple. And all that land that's been occupied by their military through unlawful wars, that's our shit. We showing you the documents. It never went through Congress. They never declared war. That means they lawfully never had the right to take it. What are we afraid of? I don't understand. What are we afraid of? Getting dead like Malcolm X or MLK? So the fear of death is going to make us hide in the closet and look at our kids and know that this shit will be worse for y'all. Like, you got to bring ass to whoop ass. It's like we believe we're going to get our ass whooped before we even get in the ring. I don't know. Yeah, what y'all got to say? It's weird to me because it's like you basically, we're not standing up because we believe we're going to lose the fight. But fight, and you don't know. You might catch him with your eyes closed and knock his ass out. But damn, when do you want to get in the ring and fight? Y'all want to say something?
No, you pretty much summing it up. I agree. We have to be able to take a stand for something. I mean, you know, we just taking blow after blow after blow. We're not even trying to make any type of forward movement. We just taking what's given to us. So I definitely agree. We gotta stand up, you know, and death and blood just maybe in the cars is gonna happen, you know, but somebody gotta do it.
Absolutely, absolutely. I mean, shit, that's one thing that's guaranteed. We all have to transition. So how do you want to transition, basically? Do you want to transition with you feeling like, okay, I've made an impact and I've done something that's going to be beneficial for, you know, my lineage, my children's children, or do I just want to stand idly by the side and say, well, I got my trinkets. I was able to, make it to a certain status under this government and I survived not getting my head bashed in, but I don't know about my family. I don't know about, the next generations of, my group. And if that's part of you, or if that's your mindset, then you can go ahead and kill over now. Because there's no point of you continuing that mindset down the line. So yeah, at this point, there's no other option. All options have to be exercised, and yeah, at some point we just have to do what needs to be done. And may the chips fall where they may.
And you, which one comes first? Next week we will be doing, is it the Gold Standard Act or Benign and Neglect? Which one comes first?
Ooh, should be Gold Standard Act. So another example of what the hypocrisy of this government. So we saw they never defined us in law. We've read damn near all the Civil Rights Acts. We haven't seen Negro, Black, Colored, African American in any of them. And now we're talking about this currency. We've been showing it, multiple times in prior videos when it comes to, what is actual payment for debt. But now we're going to see exactly what transpired, and it's going to be pretty eye-opening.
Yep. So next week, y'all, it'll be the Gold Standard Act. Let's get into it. And we can see exactly what they did. When they invited the world to be US citizens, they could no longer account and they had to take the money out the system.
Bingo.
And that brings Generation X. Everybody who's born in the 70s and beyond, 70s, 80s, 90s, 2000, 2010, 2020s. You have never been paid money from your job. That's a fact. If you're born after 1971, you've never been paid money. You've been given fiat, but you have not been paid in gold and silver coin. So they dumped down everybody under this government, and basically they're committing highway robbery.
Mm-hmm.
So we're going to get into that. And I'll just throw a last little teaser in there to show you how criminal it was. It's called the Gold Standard Act. So you would think the House voted on it, the Senate voted on it, and then the president signed off on it. Not on this piece of document, though. This act was given during a Bonanza TV show on a commercial break. And Richard Nixon came out and just read it as a station identification break. Those of us that's old enough remember when TV would go, boo, we got to important that station identification break. So the Gold Standard Act didn't even go through Congress. They literally took the money out the system unlawfully. Does that rhyme with everything we've been telling y'all? This whole shit is criminal. So it's all mental with us. Chief Quietwater, anything you want to say in closing?
I think her laptop died on her.
Go ahead, take us out as we get ready to go into next week. We lost Chief Quietwater, but that's what we're gonna be next week. Gold Standard Act.
Yeah, it's gonna be a good one. It's gonna be a good one. Stay tuned. Definitely shout out to all of the people in the chat for rocking with us through this build. Again, this is probably the longest document we've read thus far, but it's an important one because again, we're just walking down this timeline, starting off from the unlawful warring, the treaties, to now we're coming up to present day, and it's all making sense. I think one thing we've noticed is that we're prisoners of war. We have not been again recognized by this government, and now we're seeing what this government calls money. It's not actual money, and we're also identifying that, hey, they don't even follow their own procedures. So at this point, just continue to rock with us. It's going to be a good build next week, and we'll see you all then.